Prvi panel je posvećen temi rodno zasnovano nasilje, nasilje u porodici i Evropska konvencija. Uvodnu prezentaciju će dati Síofra O'Leary, potpredsjednica Evropskog suda. Panelistkinje su Saadet Yuksel, sudija Evropskog suda, i Mirjana Lazarova Trajkovska, sudija Vrhovnog suda Sjeverne Makedonije i ranije sudija Evropskog suda. Moderira sudija Evropskog suda Armen Harutyunyan. Molim učesnike prvog panela da nam se pridruže na bini.
So, dear colleagues, let me to thank at the outset organizers for this very interesting forum and gender equality in the Western Balkans. I have to say that this is a worldwide problem, worldwide phenomena, and this is our contribution to that. And false stereotypes and degradation of mindset, these are roots of this phenomena, and that is why it is reflected in case law of our court. Now we are opening panel discussion, the topic of which is domestic and gender-based violence and the European Convention on Human Rights. And these presentations we will see that will be complementary to that one which we listen from President Spano and Human Rights Commissioner. They are covering different aspects of one holistic problem. And introductory presentation will be done by Judge Síofra O'Leary, Vice President of the European Court of Human Rights. Síofra, the floor is yours.
Thank you very much. I thought it had been left on. Good morning, everybody, Commissioner, fellow speakers, distinguished guests. It's a real honor to participate in this, the very first gender forum of the Western Balkans, organized with the support of the AIRE Centre and GIZ. And like the President, I salute the fact that we are here today thanks to the drive and dedication of Mirjana Braithwaite and her team, and the tremendous professional commitment of my colleague and friend, Judge Ivana Jelic, a national export of whom I'm sure you are truly proud. Our focus today and tomorrow will be on two opposing and somewhat contradictory sides of the same coin: how to promote women's universal and inalienable right to equality, and sadly, how to protect women from abuse, whose forms are also universal, age-old, and increasingly modern. Indeed, we need to be conscious of the fact that advances in relation to gender equality can, in certain societies, serve as a catalyst for increased difficulties in relation to gender-based violence. As a woman, a legal professional, and a European Court judge, it is a true honor to be associated with the initiatives that we're launching this weekend, and in a small, independent, hospitable country with which my own small, hospitable country identifies very closely. The topic I've been asked to address is indeed the abuse side of the coin, domestic and gender-based violence, and the case law of the European Court of Human Rights. The Convention doesn't mention either. However, our case law, in which we use the Convention as a living instrument, reflects the belated but growing awareness in European states of the endemic and hidden nature of domestic violence, violence traditionally shielded from the glare of the law and public exposure, its victims silent members of our own communities, and perhaps even of our own families. The court's docket attests to the fact that the scourge of domestic and gender-based violence is felt throughout the Council of Europe, regardless of geography. In my own country, Ireland, for example, the statistics recently published by the court services speak for themselves. The number of domestic violence charges before the first instance courts doubled between 2019 and 2020, one of the known and immediate legacies of the COVID-19 pandemic. But few of these charges result in convictions. The widespread nature of the problem should not, of course, prevent us from recognizing that in certain regions it may have its own societal and structural specificities. My brief overview this morning will concentrate on the following 4 points: the converging principles and positive obligations on states under Articles 2 and 3 of the Convention, developments under Article 8 in relation to new and pernicious forms of violence and abuse already referenced by the Commissioner, the experience of complainants in the criminal justice system, and finally, the role of Article 14, the principle of non-discrimination in this particular field. My objective is quite simple: to try to extract from the Court's case law and the toolbox the Convention provides the general principles of particular relevance to you in your roles as lawyers, investigators, prosecutors, judges, and members of civil society. Firstly, the substantive positive obligation, generally incumbent on states pursuant to Article 2 of the Convention, involves a primary duty to secure the right to life by putting in place effective criminal law provisions to deter the commission of offences, but backed up by law enforcement machinery for the prevention, suppression, and punishment of breaches of this provision. It also extends, in certain circumstances, to a positive obligation on the authorities to take preventive operational measures to protect an individual whose life is at risk. Whether this preventive operational duty arises in a particular case depends on the outcome of the first limb of what we refer to as the Osman test. In a series of cases following Opus against Turkey from 2009, which you'll hear referenced a lot this morning, cases such as Talpis against Italy from 2017, and more recently Kurt against Austria 2021, the Court has tailored the Osman real and immediate risk test under Article 2 to the domestic violence context. Recognizing that the Osman test must be assessed taking due account of the specific context and dynamics of domestic violence means concretely understanding, for example, the targeting of children in order to punish and indeed torture the primary victim of the abuse, the recurrence and possibly escalating nature of successive episodes of violence, the need to avoid a narrow incident-based approach, the realization that domestic violence is person and not place dependent, and the tendency of victims, of course, to retract statements and refuse to pursue prosecutions themselves. The Strasbourg Court, seized of Article 2 complaints, looks at the adequacy of the assessment of risk conducted by the domestic authorities, and where a relevant risk triggering the duty to act was or ought to have been identified, the adequacy of the preventive measures taken by the state authorities. The facts of the court case, a Grand Chamber decision from last year, are as sad as they are recurring in domestic violence cases. Repeated beatings, a barring and protection order, a conviction for causing bodily harm, a suspended sentence, renewed reports of alleged rape and beatings preceding the filing for divorce, a renewed barring order, and the commencement of a criminal inquiry following almost immediately the fatal shooting of the applicant's child, not at his home, but at his school. Setting out for domestic authorities what is incumbent on them in these types of cases, the court emphasized that an immediate response to allegations of domestic violence is essential. The authorities must carry out an autonomous, proactive, and comprehensive risk assessment. The reality and immediacy of the risk must be assessed, taking due account of the specificities of domestic violence cases that I've just referred to. If the outcome of the risk assessment is that there is a real and immediate risk to life, the authorities' obligation to take preventive operational measures is triggered, and those measures must be adequate and proportionate to the level of risk that they have assessed. In terms of the general principles it sets out, the Grand Chamber judgment is a testament to the road travelled by my court since Opus in 2009. But it also highlights the difficulties confronting judges, both at the European level and at the national level in cases such as these. If you've read that judgment, you'll know that the Strasbourg bench, while being unanimous on the general principles, was deeply divided when it came to their application to the particular facts of the case. It's the risk assessment, its outcome, and what triggers the obligation to take preventive operational measures which divides. If the regulatory framework is sound, as usually it is to these three factors to which you must pay particular attention. I wonder also, and this is as an aside, reading a judgment like Kurt, I wasn't a member of the Grand Chamber in this case, whether we might also need to reflect as judges on whether we are in relation to certain societies which less frequently violate the Convention, too slow to accept that such societies may, in relation to women, children, or vulnerable groups, be prone to more systemic difficulties than we like to recognize. A series of Russian cases which relate to Article 3 and which mirror the Article 2 cases I've just outlined in terms of the requirement that law enforcement machinery must prevent, suppress, and punish this type of violence, highlights how the court also responds when the first requirement, the existence of an adequate regulatory framework, is not met. In a case called Volodina, decided in 2019, the court held that Russia had not enacted specific legislation to address violence occurring within the family context, and that the existing criminal law provisions were simply not capable of adequately capturing the offence of domestic violence. This identification of structural defects in Russian law in 2019 was sadly confirmed as not having been remedied in a case called Tunikova against others against Russia in 2021. What followed in Tunikova, and it's well worth reading, was a series of Article 46 indications by my court of a breadth and nature rarely seen in a Strasbourg judgment. The court indicated to the respondent state that it needed to develop and adopt an action plan to change the public perception of gender-based violence, and it needed to envisage mandatory training for judges, police officers, prosecutors, medical staff, and social workers. In both types of cases I've examined, what the court is seeking to do is to provide tools to counteract the toleration of climates which are conducive to domestic violence or accepting of a lack of a legal response thereto. If in the majority of states with adequate legal frameworks on paper, the conviction rates in this field remain obstinately low despite the number of complaints soaring, clearly the provision of adequate training is not a general indication which should be limited to convention outliers like Russia. I turn now briefly to Article 8 of the Convention. The Court's case law in relation to Article 8 is sadly replete with cases of sexual violence and rape, particularly of minors, in which it has found substantive and procedural violations of Article 8 together with Article 3 or alone. The Court has repeatedly underlined that states have a positive obligation inherent in both Articles 3 and 8 of the Convention to enact criminal law provisions effectively punishing any non-consensual sexual act, including in the absence of physical resistance by the victim, and to apply those provisions in practice through effective investigation and prosecution. Where minors are concerned, the Court has also emphasised that these Convention provisions require the effective implementation of children's rights to have their interests taken as primary considerations. What's also worth focusing on is the living instrument quality of Article 8 and its ability to adapt to the changing reality of domestic and gender-based violence. In recent cases like Potraga against Romania and Volodina against Russia, number 2, the case from 2021, the court has taken up the issue of domestic cyber violence, finding violations of Article 8 in both cases alone or in conjunction with Article 3. Earlier this year, Grevio, the monitoring body of the Istanbul Convention, adopted its first general recommendation, which is specifically devoted to the digital dimension of violence against women, compensating for the fact that there are some lacunae in the Istanbul Convention. Even though it was adopted in 2011, it didn't sufficiently engage with the subject of cyber violence. The EU Commission has also just published a proposal for a directive in the field of domestic and gender-based violence, which engages in detail with the digital dimension. And picking up on a point just made by the Commissioner, the importance of the Commission proposal lies in the fact that the Istanbul Convention may, via an EU directive, be given precisely the legal teeth in some EU member states, which those EU member states, which she didn't list in totality, have been refusing to give the Istanbul Convention. I know that Judge Yuksel will address the subject of cyber and digital violence, and I won't devote any more attention to it at this stage. As regards the experience of complainants in the criminal justice system, the Court has underlined that criminal proceedings, particularly in these types of cases, should be organised in a manner so as not to unjustifiably imperil the life, liberty, security, and I should also add, human dignity of victims, and that the interests of the defence are balanced against those of victims called upon to testify. The types of problems which can be encountered by complainants in the criminal justice system were particularly well illustrated in the JL and Italy case to which the President has just referred. Criminal proceedings and the penalties imposed on those convicted play a crucial role in the institutional response to gender-based violence. And as the President underlined, it is essential that judicial authorities avoid reproducing sexist stereotypes in court decisions. The facts of a case like JL may be particularly stark, even disturbing, but at member state level they are also relatively widespread. Some of the difficulties challenged by the applicant in the JL against Italy case have been challenged following high-profile rape trials from Belfast in Northern Ireland to Pamplona in Spain and beyond. And in Northern Ireland, the neighbouring jurisdiction to my own, a special commission was set up to establish how best to protect complainant and accused, given the public's insatiable interest in such trials, particularly when high-profile individuals are involved, and given the prejudicial effects to the trial, the accused and the accuser, of social media use, which we know nowadays is absolutely rampant. As the resulting report emphasised, alleged victims have to navigate a system which is designed principally for police and professional lawyers at what is probably the most vulnerable point in their lives, and the difficulties that they encounter can feel or can actually be insuperable. There is a natural interplay between the Convention articles I've just referred to, Articles 2, 3, and 8, in the context of domestic violence. All of these provisions aim to protect an individual from infringement of their physical and psychological integrity. But what role, if any, should Article 14 play in this field? The principle of non-discrimination, given that under the Convention it enjoys no independent existence. In 2009, the Court decided in Opus against Turkey to have recourse to Article 14 combined with Articles 2 and 3 for the first time in the domestic violence context. Statistical evidence presented to the Court pointed to features common to reported victims of domestic violence in the respondent state, Turkey. The available domestic remedies didn't function effectively. Complaints were not investigated, and crucially, sentences in the event of convictions were mitigated on the grounds of custom, tradition, or honour. The Court deduced from the material before it a pattern of toleration and passivity on the part of the authorities in relation to domestic violence. It's important to stress an obvious but very important point here. When Article 14 is engaged, the state is not held responsible for perpetrating domestic or gender-based violence. It is the conduct of state officials when applying the existing criminal law provisions to such violence and its victims, which is the subject of Article 14 complaints. The change of tack or direction in Opus followed in other cases subsequently, like Eremia against Moldova, Volodina against Russia, and again Tunikova against Russia, is fundamentally important in my view. Having regard to the terms of specialised international instruments, not least the Convention on the Elimination of All Forms of Discrimination against Women, the Court now recognises that domestic violence is a form of discrimination against women because they are women, and that a state's failure to protect women against domestic violence or to respond to such violence can breach women's right to equal protection before the law, irrespective of whether the state's failure is intentional or not. The consequences of the Opus case went far beyond the judgment itself, because it was the Opus case which led to the adoption of the Istanbul Convention, to which the Court now refers frequently, if not generally, in its case law in this field. However, the Court doesn't systematically engage with Article 14 when it's pleaded by applicants. This means that our legal response to domestic violence is scattered across different Convention articles, Articles 2, 3, 4, and 8 of the Convention, sometimes in conjunction with Article 14, but sometimes not. In some cases, I have to stress the Court has no choice but to focus on a substantive Convention provision, such as Article 2 or 3, and on procedural failings by the state under that provision, since it mightn't have sufficient material to go further. However, it has been suggested that Opus against Turkey set a particular standard before Article 14 of the Convention could be engaged. A simple failure to deal with violence wouldn't suffice. Rather, there had to be proof of the authorities repeatedly condoning such violence and reflecting a discriminatory attitude towards an applicant as a woman. However, what type of prima facie evidence must an applicant produce to establish that the acts or omissions of a respondent state in the context of domestic violence are discriminatory? The Opus case was groundbreaking in Strasbourg, but that case and its facts actually pointed to discrimination and bias on a colossal and systemic level in Turkey. In concluding in a case called A against Croatia in 2010 that the applicant had not produced sufficient prima facie evidence to support her Article 14 complaint, the court held, and I quote, she had not submitted any reports in respect of Croatia of the kind concerning Turkey in the Opus case. There are signs that the Istanbul Convention is now interacting with our convention and relevant case law to lower what some have regarded as this excessively high threshold in relation to Article 14 complaints. And as a judge of the European Court, I would say that this is very much to be welcomed. We know that putting in place a legislative framework allowing the authorities to take measures against accused persons is simply not enough. If an applicant complains under Article 14 combined with Articles 2 or 3 of the Convention, it is because of state failings in their individual case. When structural bias has been shown to exist, see cases like Opus or Tunikova, applicants do not need to prove they are also victims of individual prejudice. However, in my view, the court's case law is for the time being insufficiently clear on what an applicant complaining of bias or prejudice in the authorities' response to their individual case must prove and when the burden of proof shifts. The fact that domestic violence is rooted in gender equality and a manifestation of structural discrimination should surely not mean that an Article 14 complaint can only be made out if the applicant proves structural discrimination encompassing both the perpetrator of the violence and the authorities' response to that violence. Indeed, in many of these cases, the facts of Opus, Kurt, and other cases point to this phenomenon. We see indices of intersectional discrimination at play, with reference to which the court is only now beginning to show increased awareness, as the President explained this morning. In my view, in future cases, the court will have to pay more attention to questions relating to the burden and standard of proof under Article 14. At present, despite Article 14 complaints, usually following on from established failures by the state authorities in relation to their positive procedural obligations under Articles 2 or 3, the court may sometimes be requiring individual applicants to displace a misplaced burden of proof in relation to collective difficulties, bias, and burdens borne by their gender. The time has come for me to conclude, and I'm well aware in this very short introduction that I haven't been able to cover all aspects of the topic, which I hope we'll explore together during the question and answer session. But I have tried to point out to you in the short time available to me the salient aspects of the case law and to demonstrate what the Strasbourg toolbox both offers you and requires you to do in this field. You will notice in conclusion that I haven't referenced the court's oft-repeated reminder in cases like Konstantin Markin against Russia, referenced by the President, to the fact that the advancement of gender equality is today a major goal in the member states of the Council of Europe. As I pointed out in my introduction, we meet over 2 days to discuss both how to protect women from abuse and how to promote their equality. The urgent need to improve our response to the abusive side of the coin shows how distant, for many female members of our societies, the long sought-after goal of equality remains. As the Deputy Prime Minister said earlier this morning, we, men and women, fathers and mothers, brothers and sisters, sons and daughters, we need to look this truth squarely in the eyes. The law can help to change culture, but its effectiveness is dependent on our recognition in the first place that the culture has to change. Ladies and gentlemen, many thanks for your attention, and I look forward to engaging with you during the course of the day.
Thank you, dear Síofra, and thank you, first of all, that you pointed out that this is not neither political, geopolitical, legal crisis. This is a cultural crisis. This is a crisis of way of thinking. And on the one hand, we have countries where the legislation is very well elaborated, but it is not working. But on the other hand, we have countries, and Opus versus Turkey and Tarpi versus Italy show that even on the level of legislation, these stereotypes are reflected. So, and when President Spano underlined Carvalho, Pinto de Sousa, Morris versus Portugal, this is a very good case to show that we are dealing with cultural crisis, with degradation of mindset. The reasoning in this case, exactly good example of that. And now, dear colleagues, we have two panelists. Saadet Yuksel, judge on the European Court of Human Rights, and Mirjana Lazarova Trajkovska, judge on the Supreme Court of the Republic of North Macedonia, our former colleague, and she was a president of first section where I started as a judge my duties. So, and I know that they will elaborate all these questions and problems which were touched upon by President Spano and Vice President O'Leary. And dear Saadet, the floor is yours.
Thank you, Mr. Chair. Good morning. It's a pleasure to be here at AIRE Centre's Gender Forum. So I would like to thank all the organizers, and I'd like to extend my sincere appreciation, special thanks to dear friend, dear colleague Judge Ivana Jelic for all her contribution to the Gender Forum and acting as a bridge between Montenegro and the court. I would like to thank her as a friend, but most importantly as a female judge who has contributed greatly to the work of the court in improving women's rights in the Balkans. Many thanks to dear friend, dear colleague, Vice President Judge O'Leary for her comments systematizing case law. I'll continue to the discussion that Judge O'Leary began discussing the court's case law and to formulating a gendered understanding of domestic violence against women, and then discussing the new developments of domestic violence, including an online dimension through cyber bullying and other acts disproportionately targeting women. So let me begin with a discussion regarding domestic violence as a human rights issue. Although there is not a singular definition of the complex and multi-faced issue that is domestic violence, it is generally understood to include physical, psychological, sexual or verbal abuse, financial coercion, which is undertaken in the realms of an intimate or personal relationship. Sadly, the reality is that women suffer disproportionately from domestic violence. Why do I say this or confirm or repeat this simple fact? Because as mentioned by Judge O'Leary in Opus versus Turkey, it was noted that men may also be the victims of domestic violence, and indeed that children too are often casualties of the phenomenon, whether directly or indirectly. But sadly, as I said, the reality is that women suffer disproportionately from domestic violence. The WHO, the World Health Organization, reports that nearly 1 in 3 women suffer domestic violence across their lifetime from an intimate partner or sexual violence from a non-partner. And this number has not decreased over time. And in fact, domestic abuse has managed to transform with many variables, making its reduction extremely complex, like COVID-19 pandemic. It has presented new challenges, allowing domestic abuse to flourish as people were forced to remain in their houses, prohibiting victims from escaping their abusers. And UN Women has termed this the silent pandemic, as they report that there has been an increase to domestic violence allegations to local police and authorities in 50% of countries. So as mentioned, the court has developed jurisprudence, significant jurisprudence on domestic violence and the right to life as per Article 2 of the Convention, starting with Kontrova versus Slovakia. Given the time limitation that I have, I will not get into details the cases that I will mention. But I have to say, starting, since its judgment in Kontrova versus Slovakia, the court has found violations of the convention in relation to domestic violence under Article 2, 3, 8, and 14 of the convention, as mentioned by Judge O'Leary. In Opus versus Turkey, landmark judgment to my own country, the court criticized the national authorities' failure at the time to implement a system for prosecuting and punishing perpetrators of domestic violence. Again, I'm not going to repeat the facts, and I'm not going to get into detail. I'll take the liberty that Judge already comprehensively talked about the case. But I have to maybe just underline again, the Opus was a seminal case, as it was the first time in a case concerning domestic violence that the court held that in conjunction with 2.3, there was a violation of 14, the prohibition of discrimination. As regards Article 8, I will say the court had previously been hindered by this public-private divide as contained within Article 8. To my view, it is especially problematic for domestic violence, as women are victims of domestic violence at the hands of non-state actors, and the violent conduct was often occurring at their homes, which did not always surface in the public sphere. So what I see, there was a kind of historical assumption that domestic violence did not fit within the state-centering paradigm of human rights law. And the court's legacy in Opus has been summarized in many sources, including academic sources, as what the court makes clear in Opus is that to simply treat a case of domestic violence as a private matter is not an option. And this determination, to my view, brings into line the understanding of domestic abuse as a gendered issue, similar to definitions provided by international bodies. Like, I mean, I do include CEDAW and Grevio. I mean, why do I say this? Because it's understood that the court filled the legal protection gap and has interpreted the convention, as mentioned by Judge already, in its normative environment, having interpreted the convention in light of ongoing discussions internationally, ultimately strengthening the protection of human rights through strengthening and thickening. And in light of this international discussion and progress, further Article 2 cases have been considered, such as the case of Tersana versus Albania. Again, without getting into the details, I think the court then continued to deepen the gender dimension of domestic violence in TM and CM versus Moldova, and to my view has championed women's rights, stating the prohibition of gender-based violence against women has evolved into a principle of customary international law. Why do I say this? Even as to amount to ill treatment within the meaning of Article 3 of the Convention, the court has taken significant strides in evolving its understanding of domestic violence. And as you will understand, I'm talking about Volodina versus Russia. So the court's characterization of domestic abuse as amounting to ill treatment, to my view, demonstrates significant forward thinking from the court, recognizing that both physical and mental abuse can be as severe as ill treatment within the meaning of Article 3. The cases that I mentioned may seem contrasted with the court's judgment in Kurt versus Austria from 2021. I'm not going to make, elaborative comments. First, Judge already mentioned comprehensively Kurt versus Austria, and the second reason is, as some of you may already aware, that 6 other judges, including myself, argued that overall response from the authorities was not adequate or sufficiently comprehensive. What was the main understanding of this dissenters? Just with one sentence, was thought that could be used an opportunity to define and apply the core principles in relation to protection of women and children in domestic abuse settings. Although the majority opinion in court may have been criticized as kind of inconsistency in the court's jurisprudence on domestic violence in some academic commentaries, to my view, the court has not departed from its case law on the matter as seen in Telitser versus Georgia. And Telitser demonstrated that domestic authorities must still do more to prevent gender-based crimes, such as femicide, which are sadly still prevalent in society. And there are, as mentioned by Judge already, there are respective proposals from European Parliament and the European Commission. Just one sentence, I do believe these are also demonstrating a harmonized approach throughout European and convention states to tackle domestic violence in all of its forms. The second issue that I will discuss very briefly is online violence, including cyberbullying. So as mentioned by Judge already, new forms of domestic violence in the online sphere providing a new challenge for the court. And the issue of cyberbullying and online violence has brought a new frontier to the issue fighting violence against women, particularly with our increasing reliance on new technologies and social media. The WHO estimates that 1 in 10 women have already experienced a form of cyber violence since the age of 15. I'm aware that cyber violence provides difficulties for the law to grapple with. I mean, considering that technology often develops faster than the legislators and even faster than the courts. So it's not easy to keep up with. But it is important to consider that digital forms of gender-based violence can exacerbate intersecting forms of discrimination, such as disabilities, sexual orientation, migration status, or celebrity status. Across the UK, US, South Africa, and Chile found that senior female politicians are more than 3 times more likely to experience derogatory comments related to their gender on Twitter compared to their male counterparts. These women are also significantly more likely to experience online insults and offensive comments, with research demonstrating up to twice as many. Much like the progress made by other international bodies, again, I include CEDAW Committee, Grevio, and the international bodies mentioned by Judge O'Leary, to my view, the court's jurisprudence has similarly positioned itself as a leader in addressing online violence against women. Recent case, Potraga versus Romania, as you all know, the applicant criticized domestic authorities' refusal to consider her complaint concerning her former husband's breach of confidentiality of her electronic correspondence, which was closely linked to her complaint of domestic violence, and the court held that there had been a violation of 3 and Article 8. To my view, the court's decision in Potraga was very forward-thinking, acknowledging that technology-facilitated privacy invasions can constitute a form of domestic violence, as the publishing of private information online, accessing ex-spouse's computer and social media, so forth. So the wider recognition of what can constitute domestic abuse very well shows that what may nowadays constitute domestic violence. So domestic violence nowadays may not occur as our traditional understanding of the home environment, and with our ever reliance on technology, may now extend in the cyber realm. Actually, it extends in the cyber realm. It is worth mentioning in Potraga, the court acknowledged cyberbullying as a recognized aspect of violence against women, which could take a variety of forms, including cyber breaches of privacy, intrusion into victims' computer, and capture, sharing, manipulation of data and images, including private data. The court has similarly acknowledged that revenge porn can constitute a violation of Article 8 of the Convention and requires effective investigation and prosecution by domestic authorities. So the case that I'm talking about is Volodina versus Russia number 2 from 2021. The court was again tasked with considering whether the domestic authorities' failures to investigate and prosecute repeated acts of cyber violence against a woman by her former partner amounted to Article 8. Citing its judgment in Potraga, our court reiterated that cyber violence against women is intricately linked with physical violence against women and is yet another facet of the complex phenomenon of domestic violence. The judgment is noteworthy because it marks the first time that the court has addressed a relatively new issue of revenge porn and demonstrates, to my view, the court's ability to recognize new forms of cyber violence as acts of violence against women and violations of the Convention. It is important to frame acts of image-based sexual abuse as a physical violation on a woman's integrity, because women whose sexual images have been shared without consent have reported similar psychological impacts of survivors of sexual assault, such as post-traumatic stress disorder, anxiety, depression, and suicidal thoughts. And the court's jurisprudence on online violence against women evidence that the court is positioning itself at the forefront of tackling this issue and acknowledging that revenge porn constitutes a violation of the right to private life, I think the court has gone one step further than CEDAW committee in elaborating upon Convention states' positive obligation to conduct criminal investigations and prosecutions of allegations. And moreover, the court's approach also, to my view, aligns with the draft recommendation of Gravio, insofar as the court has emphasized contracting states' obligations to enhance the capacity of law enforcement to conduct effective criminal investigations and prosecutions. In conclusion, Mr. Chair, the court has effectively developed a gender-sensitive understanding of the Convention, which has allowed for significant developments such as recognition of domestic violence as a human rights violation, in line both UN and civil society recommendations. So the case law should provide ample optimism that it will continue to position itself as a leader in the field of gender equality, as new issues of gender equality that will arise in the future. I was talking about domestic violence, but I also hope that international or regional legislation will complement the court's forward-looking approach in protecting women in the online sphere. So I thank you very much for the attention. I apologize if I exceeded my time. Thank you.
Thank you, dear Saadet, but I wasn't going to. So you could have entered another 2-3 minutes, but it's okay. So, dear colleagues, now, with your permission, I'm giving floor to Mirjana Lazarova, Trajkovska, judge on the Supreme Court of Republic of North Macedonia.
Thank you, dear Armen. First of all, allow me to say a few words in the local language. Dragi prijatelji Crnogorci, hvala na gostoprimstvu. Draga Ivana, hvala što ste ponudili Crnu Goru kao zemlju domaćina. Dear Biljana, thank you very much for organizing this event. It's nice to be among former colleagues. It's nice to be with sitting judges of the European Court of Human Rights, but also with many friends and colleagues from the region. I was attending many conferences, many forums in this region on different topics, but I consider this one of extremely big importance. Being now judge of the Supreme Court of the Republic of North Macedonia, I can combine my knowledge from Strasbourg, but also I can see how things are developing in the region. And that's why I will focus probably on some aspects which are linked with the way how convention is perceived and implemented in the region. It was already mentioned this morning that all countries in the region have ratified the two most important conventions. Ivana mentioned that UN Convention was on elimination of all forms of discrimination ratified by all countries, but also Istanbul Convention, the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence. This is the full name of the Istanbul Convention, and from now I will refer only to Istanbul Convention. Now, by ratifying the Istanbul Convention, our countries overtook the obligation to bring their legislation in compliance with the Convention, and in order to prevent and protect violence against women, and also with the focus on domestic violence. And countries in the region have introduced the Istanbul Convention in their legislation. I can say that my country as well. There have been changes in the criminal code, changes even in criminal codes, but also in the legislation which is directly linked with discrimination or fighting discrimination. But that, as it was already mentioned, is it enough to change legislation? It's not. And we have seen on concrete cases that it's not only that our legislation has been changed, it was done in a perfect way. We can say that now we have perfect legislation. It follows the case law of the European Court of Human Rights, The Istanbul Convention is well introduced in the legislation, but yet the results in practice are not satisfying. And this is the reason why we are meeting. This is the reason why we should discuss how to approach in practice, how to give a practical forms of what was already done in paper. Preventing domestic and gender-biased violence is, in my view, one of the essential elements of preventing gender-biased violence in our countries from the beginning, from the moment when the victims will approach to different institutions, starting from police, from social services, offices of the ombudsman. And that's why we have among us not only judges, we have also our colleagues from the offices of the ombudsman's office. Now, while the European Convention on Human Rights does not specifically refer to domestic violence, the court evolving jurisprudence in cases concerning gender-biased violence has found violations of convention articles in this context, and many of these cases have been already mentioned by my colleagues. I will just say that when the case linked with the domestic and gender-based violence will reach Strasbourg, it will refer mainly on Article 2, Article 3, Article 8, it will refer on Article 13, and most of the applicants will say that there are no effective legal remedies at the national level. They are legal remedies, but are they effective? This is the problem. And most of the applicants will complain that they have been victims and also they have been discriminated. We have seen not only women, men are also approaching Strasbourg claiming that there was a gender-based discrimination. Now, Opus was mentioned quite often from my colleagues, and I consider still Opus versus Turkey as an extremely important judgment because Opus was also inspiration among other judgments for Istanbul Convention. Let's not forget that in Opus, the judgment in itself, the international organizations at that time, Amnesty International and Diyarbakir Bar Associations, were raising awareness about domestic violence in the region of Diyarbakir, where in fact the case was happening, where the applicant lived at that time. All the victims in that region were women, and these women were illiterate or of low level of education and generally without independent source of income. Most of them were by Kurdish origin. The courts of these international organizations were suggesting that domestic violence was tolerated by authorities and that the available remedies did not function effectively. Police officers did not investigate complaints, and they were, in most of the cases, suggesting the role of mediator who will try to convince victims to return to the home of the person that was violating. Domestic violence, we can say, does affect mainly women, while the general and discriminatory approach of Turkish authorities is not unique. We can see this all over the region. We can see this in my country. We can see this in Montenegro. We have cases from Montenegro already in front of the European Court of Human Rights. Being judged at the Supreme Court of Human Rights, quite often I'm dealing with cases in connection with domestic violence and gender-based violence. And sometimes I'm surprised by the approach of my colleagues, my male colleagues, which are approaching with a lot of stereotypes and it's at the same time with low level of sensibility for the gender. For example, there was a case of young girl, younger than 14 years, and she was victim of sexual abuse by men who claimed in front of the court that he was going to marry her. And for my colleagues, it was one of the elements that should be considered. He was going to marry her. I think that this form of stereotypes and this form of low level of sensibility for gender-based violence should be discussed. We should try to raise awareness among judiciary, among those who are judging. So if we can say that the police and prosecutor were without sensibility for the case, we cannot find excuse for the judges when the cases will come in front of the court. Tershana versus Albania, I was practicing the name of the case with my colleague from Albania, but it's difficult to pronounce correctly, is a case which I'm observing from the standpoint of effective or, let's say, ineffective investigation, because this was the reason why this case came in front of Strasbourg. It came because of the failure of authorities to reach with special diligence in conducting thorough investigation following acid attack against a woman. And this case is linked with Article 2 on procedural aspects. In this case, the court had to examine whether the investigation carried out by the state authorities had met the requirements of the procedural limb of Article 2, having regard to the general situation of women in Albania, in which the acid attack had occurred and the authorities' response in the investigation of this case were not satisfying. There was no effective investigation. And here in this case, again, we see reports of non-governmental organizations, reports of international organizations that are pointing out that this form of violence against women was present in Albania at that time. Another case that came recently from the court on 10th of February 2022 is the case of A and B versus Georgia, and it's about the failure to protect a Georgian woman from domestic violence perpetrated by her former partner, who used his position as a police officer to seek impunity for his behavior, and failure to conduct effective investigation into her murder. And of course, the court in Strasbourg came with finding violation on procedural and substantive aspects of Article 2 in conjunction with Article 14. I'm mentioning this case because in many cases that are in front of our national courts, we have as a perpetrators, police officers, or some high-level officials which are supposed to protect life and dignity. And they are reaching for violence, and they are using violence. And the problem is the way how the investigation is approaching in these situations, and the protective approach of colleagues, policemen or prosecutors when it comes to this type of cases. States should also take measures to protect victims from further abuse while the investigation is going on, because it's difficult to be victim and to be imposed again on possible double victimization during the investigative phase. And to conclude, the Convention is a living instrument, the interpretation of which must take account of charges regarding the role of women in society, and in this respect, we can say that the Court of Strasbourg has emphasized that differences in treatment between men and women cannot be justified on the basis of stereotypes, presumptions of tradition, outdated notions about the respective role of men and women in society. Let me say, my dear colleagues, that we, as professionals from the region, must effectively protect and enforce the rights and freedoms related to gender equality contained in the European Convention on Human Rights, but also in our national legislation. That is why, perhaps, this was mentioned by Biljana and Ivana this morning, most important for us would be to establish a regional network to bring together gender champions in the judiciary for mutual support and exchange of good practices among female and male judges in the region. The court rulings in recent years have shown that gender equality is an evolving issue and that gender inequality is two-sided and can harm men equally just as much as women. And we have seen this in the case of Konstantin Markin, but also in the case of B versus Switzerland. So thank you very much, and I hope this will provoke further discussion. Thank you.
Thank you, dear Mirjana. Dear colleagues, I was asked to inform you that we will start our lunch at 2 o'clock, so we have more time, and I would like to take profit. It is not. We have more time, so we will come after lunch and we'll start our second part at 2 o'clock, and I would like to take profit on this and a little bit to exceed my role as moderator and to add a couple of words about this topic before opening the floor for discussion. First of all, I would like to thank Biljana and Ivana for inviting me, and because Montenegro as a civilization, as a country, is very close to Armenian soul, and I am very happy to be able to see this country. Unfortunately, weather is not giving us possibility to see more, but no need to drink all water or sea to understand that it is salted, that even this small part of Montenegro is enough to understand what kind of beautiful country is this. And of course, in contribution of Ivana in this, because as a person who came from United Nations to court, I know how she was respected in Human Rights Committee, and thank you, Ivana, for this invitation. Dear colleagues, I would like to say that there are two constitutional principles on which our court is functioning and convention is democracy, rule of law, and effective protection of human rights. And democracy and rule of law, it is not only about the legislation, it is about culture, because we have many, I came from Armenia, post-Soviet country, and we know many member states where legislation, constitution, they are quite well elaborated, but they are not working. That is why sometimes we can say that we have a constitution, but we don't have a constitutionalism. We have a parliament, but we don't have a parliamentarism. There is no phenomena. There is an institution, but it is not functioning. And I think the false stereotypes, the type of which this gender equality, it is something which can be taken and challenged via interdisciplinary way. That's why we, as judges, lawyers, we have our limited part of this, but we have to cooperate with specialists from culture, from education, from psychologists, and I don't know whether it is possible, Biljana, but it is my wish that, first of all, your organization, as advice of individual rights in Europe, extended geography, and extend this interdisciplinary dialogue as well, because it is the gender equality, this is a very deep, very serious problem. I will give you just one example from psychology to understand how it is important. It is proved by scientists that 70% of our personality formed during first 5-7 years. The rest 30 years already we are getting during the rest part of our life. And it is not difficult to understand who is more influential during this period of time, mothers. And what if they are discriminated, if they are downhearted? Impossible to create happy society at cost of happiness of women. That is why we have to understand my message to men that what we are doing with the women in our societies, it will come back as a boomerang to us, to the future of our children, and to the quality of societies where we are living. This is a very serious problem. And behind of this crisis, political, geopolitical, is a crisis of false stereotypes, and one of these are related to women. I was a head of human rights monitoring mission in Ukraine during the first war, and what was happening in this eastern part of Ukraine with women, which was a gray zone in regard of international protection of human rights, it was awful. I want to say that it is very important, and I'm very grateful to organizers for this topic and for this question, and this discussion, because we have to talk about this seriously, not to go too much in the legal technicalities, but to create problem and to understand how to tackle this. So I will stop here, and I will open the floor for discussion. Dear colleagues, if you would like to ask questions to panelists or to speakers, or to have some short intervention to present your way of understanding of this, so please, the floor is open. And please, before, just present yours. Yeah, thank you.
Ja sam Mato Tadić, predsjednik Ustavnog suda Bosne i Hercegovine. Gospodine predsjedavajući, dame i gospodo, kolegice i kolege, prije svega bih htio čestitati na odabiru teme. Gospođa Braithwaite već kontinuirano ima odlične ideje i za ove pravosudne forume koji već kontinuirano, pa nisam siguran bilo da li 6-7 godina držimo. Ovaj današnji forum je nastavak u stvari onog koji je prije 7 dana bio u Bosni i Hercegovini, gdje je bila tema femicida. I to je dobro da možemo zaokružiti raspravu u cjelini vezano za ovu temu. Hvala predsjedniku Spanu i sucima Europskog suda za ljudska prava što su našli vremena da sudjeluju. Za nas u nacionalnim sudovima, bez obzira redovnim ili ustavnim sudovima, je vrlo bitno to, jer mi se svi manje više, neko u većem obimu, neko u manjem, oslanjamo na praksu Europskog suda za ljudska prava. Bosna i Hercegovina je u tome posebno specifična, jer je Europska konvencija sastavni dio Ustava, ugrađena je u ustavno-pravni poredak. Kako je već istaknuto, mislim da je sutkinja Mirjana rekla, većina država ili sve, nisam provjeravao, donijeli su normativni dio. Reći ću za Bosnu i Hercegovinu da ima na razini države zakon o zabrani diskriminacije, zakon o ravnopravnosti spolova, zakon o zaštiti od nasilja u obitelji itd. Čak ovaj zakon o ravnopravnosti spolova propisao je i kazneno djelo, krivično djelo zbog nepoštivanja tog zakona, gdje je zapriječena kazna zatvora od 6 mjeseci do 5 godina. No, ovaj dio jeste bitan, ali treba sad vidjeti kako to u praksi funkcionira i kako se primjenjuje. To je najbitnije za realizaciju prava. Ovdje je jako puno danas spominjan predmet Opus protiv Turske, posebno se osvrnula i sutkinja Yuksel. On je donesen, koliko ja znam, 2009. godine, odnosno donesena odluka, odnosno predmete iz 2009. I ja smatram da je to doista vodeći predmet koji je konstatirao da nasilje nad ženama može se smatrati rodno zasnovanim nasiljem koji je oblik diskriminacije žena. I sad dalje je razvijan u nekim drugim predmetima, odlukama, o čemu je govorio i predsjednik Spano. Praksa mog suda, praksa Ustavnog suda Bosne i Hercegovine ukazuje na to da u Bosni i Hercegovini je evidentno postojanje problema nasilja u obitelji. Međutim, imamo jednu interesantnu situaciju. Za razliku od Europskog suda za ljudska prava, gdje se pojavljuju žrtve nasilja pred Europskim sudom za ljudska prava, tvrdeći povredu Europske konvencije, pred Ustavnim sudom se kao apelanti uglavnom pojavljuju počinitelji nasilja. Počinitelji nasilja u obitelji koji su između ostalog pozivaju na povredu prava na obiteljski život, članak 8, pozivaju se na povredu članka 6 da nisu imali dobro pravično suđenje pred redovnim sudovima. Kolegica s moje strane desne je predsjednica Vrhovnog suda Federacije Bosne i Hercegovine. Pozivaju se na članak 14 da su diskriminirani u odnosu na žene. Razlog takvog pozivanja, odnosno obraćanja Ustavnom sudu, jeste što su naši redovni sudovi, primjenjujući dakle zakone, donosili i utvrđivali povrede, donosili odluke, utvrđivali povrede nasilja prema Zakonu o zaštiti od nasilja u obitelji. I tako se pojavio jedan predmet kod nas gdje je redovni sud utvrdio da je apelant prema supruzi počinio radnje nasilja iz Zakona o zaštiti od nasilja u obitelji Federacije, te mu izrečena zaštitna mjera udaljenja iz kuće i zabrana vraćanja u kuću u trajanju od 6 mjeseci i zaštitna mjera zabrane uznemiravanja ili uhođenja supruge u trajanju od 2 godine. On tvrdi da je time povrijeđeno njegovo pravo na dom, članak 8, da nije imao pravično suđenje jer su sudovi između ostalog bili pristrasni, a da ovdje samo malo napravim možda i šale, u redovnim sudovima u Bosni i Hercegovini 65% je žena. Ne znam kako je u drugim, ali pretpostavljam da je slično. I tvrdi da je između ostalog imao pristrasno suđenje, jer su žene bile i u prvom i u drugom stupnju uz sud. Sudjelovale u odlukama koje su donesene. I Ustavni sud je istaknuo da odluka suda redovnog o izricanju zaštitnih mjera koja se donosi radi osiguranja nužne zaštite zdravlja i sigurnosti osoba izloženih nasilju, te sprečavanje nasilja u obitelji nesumnjivo predstavlja legitimni cilj u javnom ili općem interesu. Odnosno, nužnu mjeru u demokratskom društvu radi zaštite prava i sloboda drugih u smislu članka 8 Europske konvencije, to jest u konkretnom slučaju radi zaštite žrtve nasilja i sprečavanja i suzbijanja daljnjeg nasilja nad žrtvom, apelantovom suprugom. U konačnici, prolazeći kroz testove koje prolazimo u pogledu odlučivanja imali povrede ili ne, Ustavni sud je zaključio da osporenim odlukama redovnih sudova nije narušeno ni načelo proporcionalnosti između apelantovog prava i legitimnog cilja koji se želi postići. Apelacija je odbijena. Slična je situacija u jednoj drugoj apelaciji gdje je Ustavni sud zaključio da odlukama o izricanju zaštitnih mjera nije narušeno načelo proporcionalnosti između apelantovog prava na obiteljski život i legitimnog cilja koji se želi postići, a to je osiguravanje nužne zaštite zdravlja i sigurnosti osoba izloženih nasilju te sprečavanju nasilja u obitelji koji su zasnovani na principu rodnoj ravnopravnosti. Ova samo dva, ima još takvih slučaja koje sam spomenuo ovdje, ukazuju na postojanje nasilja, ali ono što je na neki način dobro i pozitivno ukazuju da redovni sudovi naši bave se ovim pitanjem, da primjenjuju norme, zakone koji su na snazi i mi kroz naše odluke, normalno poštujući sve standarde, za sada smo im apsolutno davali podršku, nismo ni u jednoj takvom situaciji našli povredu. Poslije pauze, poslije ručka ću, nadam se, imati priliku sudjelovati u raspravi, iznijeti jedan vrlo, vrlo interesantan slučaj koji se pojavio, a odnosi se na prije svega članak 8 i članak 14, a ovdje će se zaustaviti. Hvala.
Thank you very much. So, any other intervention or question? Yes, Mirjana, please.
Perhaps more of a remark. I think we've got another 15 minutes roughly for the discussion, so I want to get in my request before we, I think we sort of, there is a consensus sort of in the room that sort of judiciary has part to play, but you know, gender stereotypes and prejudices are a wider issue. And I think in many ways we have a perfect cocktail at present in the region. We are in transition, we have economic difficulties, we have traditional societies, and we also have rise in right-wing policies or parties present, which is all sort of linked to rise in violence in societies in general and gender-based violence. And I think that link is sort of very evident if you look at the research of sort of serious organized crime. Very often the perpetrators recruited have been sort of in their childhoods exposed to witnessing violence, and therefore are less, or sort of their tolerance threshold for violence is sort of higher. So I think we all agree it's a societal issue. We all agree something needs to be done. I mean, what I sort of just have to go back to the case that Mirjana brought, because it's sort of fresh, and it's from the Supreme Court of her country. And just the fact that some of the judges sort of felt that the fact that this sort of man who raped a girl who is under 14 in fact wanted to marry her, he just didn't know how to say it, so he sort of raped her instead, is just, I think, sort of, we sort of need to deal with these stereotypes, and we need to, because we can digest the case law. So my request to the working group in the afternoon is to help us, because what we are trying to do within this network, and I've got Kosana here, who's helped us with our femicide research we've done in Bosnia and Herzegovina, and just the catalog of alleviating circumstances that judges resort to is seemingly endless, and it's so ingenious. And if we could just direct that ingenuity into actually asserting women's rights, we would do very well. So if you can help us actually, you know, because we all say we need to address stereotypes, how exactly? Because we're all products of our society. I think we can sort of all digest the legislation and the case law, but then that spin that's sort of put on it that is so hugely damaging, I think all of you in the room will be in the best position to advise us. So for the working group that's talking about gender-based violence, it'd be really fantastic if you could give us some practical pointers as to what is it that we should be doing so that attitude of prosecutors and judges and sort of police changes. Thank you.
Thank you, Mirjana. So, yes, please.
Just one sentence to add, because that's a crucial point in our femicide research, not only in Bosnia but also in Serbia, and now we're starting also in here in Montenegro and in Albania. So the issue of so he kills his wife, ex-wife, girlfriend, so on. And then in the explanation of the judgment, it's written that he was a married family man. And that's like, that's the reason that the court had eased on him. So it's kind of course, not every single judgment, but there are a lot of issues. So family man, father of, I don't know, 2, 3 children, and the young person, older person, with some health issues. So it's unbelievable how things they are putting into explanations. That's something we, and we all know that the final, punishment depends on those circumstances. So it's great if we could address it during afternoon panel. Thank you.
Thank you very much. So, dear participants, yes, please.
Thank you. Good morning, everyone. It's a great pleasure to be here. By way of introduction, I'm Gresa Tsokanimoni. I represent Kosovo, and I'm the head of the Constitutional Court of the Republic of Kosovo. I'm taking the floor for a very brief intervention, as I know that the agenda in the afternoon and after the break is going to be consisting in working groups where we will be able to discuss in more details the practical aspects of how we include all the research that has been done, as well as the case law of the European Court of Human Rights, and use the privilege of all the great speakers that we have here in order to discuss some practical aspects of how we incorporate these findings into the case law that we have. I also want to focus just on three key things briefly. First of all, emphasize the importance of all of us being gathered here in two aspects. First, I think two criteria make it very important. First of all, the geographic coverage. We all share similar legal tradition, social and cultural problems. Second, I think judiciary and representatives of the judiciary don't only have a role to play. I think they have a key role to play in ensuring that the best European standards, our constitutional values and laws are in fact practically embedded into the human rights protections that we all aspire to achieve in practice. As a representative of Kosovo, I must say you all know we're not members of Council of Europe. However, this does not exclude us from the obligation to fully abide with the values of the Council of Europe, as well as other organizations, including the case law of the European Court of Human Rights. I could briefly add that our Constitution includes 9 international instruments that are directly applicable and above any law in the Republic of Kosovo. This includes the European Court of Human Rights, the European Convention on Human Rights, it also includes the Istanbul Convention more recently. But uniquely, we also have a constitutional provision that obliges our constitutional court and any other authority in the Republic of Kosovo making decisions there for that matter, to make and interpret all human rights and fundamental freedom based on the case law of the European Court of Human Rights. So the case law of the European Court of Human Rights is technically a source of law for all the decisions that our constitutional court makes. Now, our practice so far, as you know, we're a young constitutional court and interpret also an equally young constitution. Already has case law on the field that we are discussing today. However, due to the features of our constitutional system, primarily in two aspects. First, we've dealt with questions on whether quotas or merit should prevail. We have a couple of, in terms of representation of women in the institutions of our republic. Also, we have Article 2 cases, 2 of them in which we have actually found a violation of the state for failing to comply with its positive obligations in terms of investigation, but also protecting women after they had consistently declared that they were victims of domestic violence. We have less case law, and this is also indicative to a bigger problem in Kosovo and the region, perhaps, with parties claiming discrimination based on gender violence. We have less cases with parties claiming questions of stereotypes, and equally less questions that come due to digital advancements. Therefore, it is, however, we have recently received a number of cases which are still in review that go to speak to another problem that we should probably treat in more details in this afternoon, of how women, in one scenario, killing their husbands due to domestic violence, or how women contesting the social and cultural norms have been treated by the courts, regular courts, in terms of procedural rights as well as equality of arms. As these cases will be treated by our constitutional court, I found tremendous value that we're all together here, because our speakers have today mentioned some very important case law of the European Court of Human Rights, including some tests, what we call in our small court a Strasbourg test, which should be applied whenever we have similar questions arising. I can say we're fully committed as a constitutional court in order to abide by the best European standards, but not only, we are constitutionally obliged to follow the case law of the European Court of Human Rights. So at this point, I just want to say thank you. I'm delighted to be here, and I look forward to discussing with all my colleagues from the region the practicalities of how we procedurally embed the culture of Strasbourg into our courts and the region. Thank you.
Thank you very much. So we have time for 1-2 interventions as well. If yes, please, if you want. Yeah.
I take the floor for a few more minutes just to respond to one or two of the interventions. I said this morning when I spoke that it's an honor to be part of this initiative, but it's an honor to take part in your regional dialogue. I did think it was important in the introductory speeches to emphasize that this isn't just a regional problem, it's a problem in every single state in the Council of Europe and beyond. But of course, each region has its specificities. I intervene just to respond to the 2 points made by judges from the Constitutional Courts of Kosovo and Bosnia, because I think they're very, very important. In Strasbourg, of course, we're not dealing with criminal or penal responsibility. We're dealing with the state's responsibility under international law. But in the background is precisely the background that the Bosnian court judge emphasized, that we have not only, we have two sets of fundamental rights, those of the accused and those of the accuser. And this plays out in the background in some of the cases that we mentioned this morning. For example, in Kurt, what you very clearly see was the Article 5 right to liberty in relation to the husband and the court's interaction with that. You can have agreements or disagreements about how the majority interacted, but that was the background issue in that case. In JL against Italy, we have the Article 6 rights of the persons accused and the Article 8 rights of the accuser. And the court, of course, has to be very conscious of the fact that we're not engaging with penal responsibility, and we have to be very careful not to infringe ourselves the presumption of innocence of those who have been acquitted. Incidentally, the Grand Chamber was seized of a Croatian case. My pronunciation is very poor, my apologies. Mroavic against Croatia, which would have looked specifically at questions relating to Article 6 in rape cases in relation to the accused person. But unfortunately, the applicant passed away and the case had to be struck out of the list. What I would be very interested in this afternoon is some discussion, engagement with how national judges see the question of interaction between Articles 2 and 3 and 14. The way I've struggled with this issue, as you saw in my speech, I think it's important when judges from the European Court of Human Rights come to a regional context and try and explain what the toolbox is, that they also demonstrate a degree of humility and self-criticism. And as regards Article 14 and the lack of engagement in some cases, I personally would be quite critical of our particular court. The way I distill this challenge is as follows. But for the gender of the complainant and but for the nature of the crime reported, would the state authorities react differently? That's how I distill the question down. Now, if the answer to that question is yes, then I think this threshold idea that you have to prove massive societal or structural problems in order to get a court to listen to you, that the policeman or woman in the police station is not listening to you, I think that's where the problem lies, and Mirjana picked up on this. Very interestingly, in the JL and Italy case, what the court did, it went through all the stages of a criminal complaint, from the reporting of the complaint to investigation to prosecution to the activities in the court itself. And the reporting, investigation, prosecution were not found to be problematic. Picking up on the intervention of the Kosovan judge, it was the courts themselves, their reaction to the case and the applicant, the complainant, which was found to be particularly problematic, and therefore I fully support your emphasis on the crucial role played by judges and the judiciary. Because, as Mirjana pointed out, there are legal remedies on paper, but the question in Strasbourg that we look at is, are those legal remedies effective in practice? And it's judges who, to a great extent, ensure that they are effective in practice. It's judges who engage with the law and recognize or identify for the general public the problems in culture that they are addressing using legal tools. And it's that change in the societal conversation over which you have an absolutely tremendous influence. And I should say that, of course, we are conscious in Strasbourg, in a court where President Spana will correct me, certainly the bench is not equal men, women. That is a distant goal. We are a small minority in a group of 47 judges, and let's just say, we too, on our professional journeys, both to that court and in that court, we too have encountered or can detect gender stereotypes and bias. Thank you.
Yes, please.
Just 1 minute. I mean, Judge Mato was right when he said that the biggest number of women in basic and appellate courts in the region, and in some countries like Bosnia, even in Supreme Court and Constitutional Court, the number of women is really high. And this is a new trend in basic and appellate courts in whole countries in the region, not only in Bosnia and Herzegovina. Women are majority of judges, but yet there are no changes concerning the approach towards sensibility for gender-based violence or for domestic violence. This means that we will have to work equally with men and women judges to raise the sensibility, but also knowledge of the case law of the European Court of Human Rights. And Madam President of the Constitutional Court of Kosovo, I think that your court is doing quite well. I was visiting your court 2 years ago, and I must say that the way how you are implementing the case law of the European Court of Human Rights might be a good example for other constitutional and Supreme Courts in the region. And this is important because sometimes working on cases at the national level, we think that this is completely new. This is the most difficult case in the world, but one should always look above Strasbourg, and you will see that there are already countries that went through most of the legal questions imposed in front of the courts. Thank you.
So, dear colleagues, yes, I know, Saadet. You see that sometimes discrimination comes from other parties. So that I have a right to have lunch, but I cannot say no to my colleague Saadet, and she will have some. She will reply, and we will go for lunch. Thank you.
Very, very briefly, thanks for giving me the floor. Just for a few minutes, just to, follow up to Judge O'Leary, and sorry, I forgot your name, but our colleague from Kosovo, I fully support your argument, like judiciary is key factor in this area. So I do appreciate, I appreciate Judge Lazarova's point and President Spana's point this morning. Perfect law is not the key for perfect implementation and execution. Sometimes it is important to have law and the perfect law, but I'm not sure if we are talking about domestic violence and the gender issues. Since we are mentioning Turkish cases today, very much, it was in my speech, but just given the time limitations, I just cut it out. Ünal Tekeli versus Turkey from 2004. We'll show you how our court's case law has contributed to Turkish implementation positively, without even having the law changed. Law remains same. So what was it just like for, if it's going to be helpful. So under Turkish law, the applicant was a lawyer and took her husband's surname. She was not able to use both surnames, like her surname and the husband's surname, officially on official documents. What was the argument of the government? It is important to have the same surname in order to reflect family unit. She was refused to use her surname together with husband's surname. And you know, like our court found violation, and that with the matter from the perspective of 14 in conjunction and together with Article 8. Law is still same, but now women in Turkey are able to use their surname. So judiciary, our case law, judges, judges' views and case law is very much important in this area. Even the cases that we talk in the morning, Opus versus Turkey, I think Judge already mentioned. It wasn't the law that was criticized by the court, but it was the general and discriminatory attitude of the national authorities that need to be remedied. So I fully support European judiciary. I cannot refer to the practitioners. I don't have that experience, but I think I can. If it's going to be kind of helpful to you, just to mention, to my view, the summary of our case law on this issue. Even our court at first seemed to be barred from discussing and scoping article, the scope of widening the scope of Article 8, but I think the court has overcome these obstacles and widening the scope of Article 8, including acts of private individuals against private individuals as a matter of public interest. And then the second, I think it's added to its embed the ability to consider interrelated articles like Article 2, 3 in conjunction with 14. I think it's important for domestic violence. And the third and last point, I mentioned in the presentation, court has demonstrated a forward-thinking approach, recognizing that there are circumstances, or that there may be circumstances of such severity may amount to Article 14, the discrimination. So I think that's going to be helpful for Supreme Judges from the region and from outside the region.
So, Ivana, you wanted to say something?
I'm just going to quote something which is, I think, relevant for this occasion without taking more time, because we have the right to lunch, correct? So just one impressive quotation, which is going to echo what Judge O'Leary said. I'm sometimes asked, when will there be enough female judges on a bench? This is about US Supreme Court. And Ruth Bader Ginsburg answered, when there are 9. And people were shocked. But there had been 9 men, and nobody's even raised the question about that. Thank you.
Thank you very much, dear colleagues. And on this positive note, let me wrap up this, and we will think about that after lunch. And now let's have our lunch and our right to have a lunch. Thank you very much.